Hello, and welcome to this Gowling WLG TUPE Club webinar on TUPE and pensions. I'm Siobhan Bishop from the Employment, Labour and Equalities team, and I'm joined today by Liz Wood, who is a director, and Hannah Beecham, a principal associate, and they both specialise in that tricky crossover area of pensions and employment, and are part of our unique combined human resources solutions team. Today's webinar will last about an hour in total, and we have dedicated the whole session to TUPE and pensions for employers and dealing with some of the most common pension issues on a TUPE transfer. So, I'll now hand over to Liz, who's going to introduce those top 5 tricky pensions and TUPE issues that we are covering today.
Thanks, Siobhan. Well, TUPE is not a straightforward topic on its own. Dealing with the automatic transfer of employees and their contracts of employment, and any rights or liabilities associated with them can be painful enough at times. And then pensions are thrown into the mix. And of course, pensions are not always everyone's favourite topic. Often pensions come with a great deal of jargon, complexity and mysticism. But fortunately for you, Hannah and I both like TUPE and pensions, and we spend a lot of time working on them. So today we're here to demystify some aspects. We can't promise to categorically put every pensions and TUPE question to bed, but we do promise to explain some complex issues and to offer some solutions for the more complex areas. So here are our top 5 pensions problems for today's webinar at least. So I'll hand you over now to Hannah, who's going to cover the first 2 pensions problems, the first of which is pensions don't generally transfer under TUPE, so what do you have to do about them?
Thanks, Liz. In order to answer this first question, we need to go back to basics on what the law says about pensions on a TUPE transfer. There are 4 key pieces of legislation which have something to say about this, and they're set out on the slide. First is TUPE itself, specifically Regulations 4 and 10. This sets out the basic principles of what transfers and what doesn't. Next, there are provisions in the Pensions Act 2004 and the Transfer of Employment Pension Protection Regulations 2005, which deal with pension protection. And finally, the Pensions Act 2008 is the legislation dealing with automatic enrolment, which all UK employers now need to ensure they are complying with. So let's walk through that in more detail, starting with TUPE. Now, I always find the way pensions is dealt with in TUPE quite difficult to follow, because there are a couple of double negatives in the wording. But if you drill down into Regulations 4 and 10, you'll find what they say is as follows. First, and this is the bit you probably know already, a transferring employee's contractual rights, which are nothing to do with an occupational pension scheme, automatically transfer and become the transferee's responsibility. This is what's known as the automatic transfer principle. However, Regulation 10 goes on to say, in a roundabout way, that rights relating to old age, invalidity and survivors' pensions under an occupational pension scheme do not transfer. Occupational pension rights which do not relate to these things, sometimes known as Beckmann rights, do transfer. Now we'll come back to talk about what an occupational pension scheme is in the next question in the webinar, so let's park that point for the moment. But the question you might be asking yourself now is, what on earth does old age, invalidity or survivors' benefits mean? Well, it's an esoteric term that's taken from the European directive, but there is some case law which helps us here. In particular, a couple of cases called Beckmann and Martin tell us that rights to an enhanced pension on early retirement or redundancy do not relate to old age, invalidity or survivors' benefits, and so they do transfer under TUPE. This is why the limited class of pension rights that transfer under TUPE are commonly called Beckmann rights. What you might think of as more mainstream occupational pension rights, like the right to a pension at normal retirement date, come within the pensions exclusion, so they don't transfer. Putting all of this together, and as you can see from the summary on the slide, most occupational pension rights don't transfer under TUPE. It's only Beckmann rights and rights under personal pension schemes that do. However, just because the automatic transfer principle doesn't apply to the majority of rights under an occupational pension scheme doesn't mean that they are without protection. Pensions are an important employee benefit, and so Parliament decided that they needed some protection elsewhere. That protection is set out in the Pensions Act 2004, which says that if the transferor operates an occupational pension scheme and one of the conditions set out on this slide applies, then pension protection kicks in. If pension protection applies, then the transferee has to provide a minimum level of pension benefits to the transferring employees. Now, there are several ways the pension protection obligation can be met, which are set out on this slide, but the options all involve providing a pension scheme with a minimum level of contributions from the employer. So let's put all of those pieces of the jigsaw together. When you're thinking about pensions on a TUPE transfer, you need to first assess the transferor's pension arrangements. Second, work out if any of the pension benefits transfer automatically to the transferee because they are outside of the pension exclusion in TUPE. Third, work out if pension protection applies. And fourth, if it does, determine the minimum level of pension the transferee will have to offer after the transfer. And finally, make sure the transferee doesn't forget about automatic enrolment. If the transferee is getting new staff as a result of the TUPE transfer, then its employer duties under the Pensions Act 2008 will apply from day one. This means the transferee has to assess the workforce and any existing pension provision, and it might have to automatically enrol staff depending on their age and earnings. Okay, so moving on to the next question, which is what is the difference between an occupational and a personal pension scheme, and why does it matter? You'll remember that a few slides previously I said I'd come back to this point. The reason why the classification of the pension scheme matters is that the pensions exclusion in TUPE talks about occupational pension schemes within the meaning of the Pension Schemes Act 1993. However, not all pension schemes are occupational pension schemes. If the transferor offers a personal pension scheme and is contractually obliged to contribute to it, then that is a contractual benefit to which the ordinary automatic transfer principle would apply. The transferee can't rely on the pensions exclusion. Similarly, the pensions protection legislation refers to an occupational pension scheme rather than a personal pension scheme. So what is an occupational pension scheme? The definition in the Pension Schemes Act 1993 talks about a scheme established by an employer to provide pension benefits for the employees or categories of employees to which the scheme relates, which isn't all that descriptive. So what can I tell you that's more helpful? Well, firstly, the definition of an occupational pension scheme is mutually exclusive from a personal pension scheme. As far as the legislation is concerned, a pension scheme is either one or the other, it can't be both. And secondly, the definition has nothing to do with the kind of pension benefits provided. In practice, personal pension schemes are always defined contribution, but an occupational pension scheme could be either defined benefit or defined contribution. In practice, there are some other clues that you can look for to tell the difference. An occupational pension scheme will typically be set up under a trust and have some trustees, whereas a personal pension scheme is usually set up with a third-party provider, often an insurance company. A personal pension scheme might also be referred to as a GPP, which stands for Group Personal Pension, or a stakeholder scheme, as these are both types of personal pensions. The key point to take away is that you need to ask the question at the outset so that you can determine the pension rights that will follow from the transfer.
Thank you very much, Hannah. Moving on now to the third question, which is relating to consultation, and Liz is going to look at this. And the question is both pensions and TUPE consultation needed?
Thanks, Siobhan. Indeed, so one question that frequently comes up is how pensions changes on a TUPE transfer should be dealt with in terms of information and consultation obligations. And there are two legal duties which might arise here. The more obvious one is the obligation to inform and consult under the TUPE regulations. The sometimes less obvious duty, but one which should still be borne in mind, is the pensions consultation obligation, if only to be aware of it and then discount it if it's not relevant to you as either the transferor or the transferee, depending on the pensions changes on the table and when they are proposed to take place. Do be aware, however, that whether or not the pensions consultation obligations do apply when a TUPE transfer is anticipated is not always crystal clear in the legislation. So I'm going to take you through both of these obligations, explaining when they arise, how they interact, and how you can best approach them when a transfer of undertakings is on the cards. Let's begin with looking at the TUPE regulations. Who has the obligation to inform and consult? Well, the TUPE regulations require the employer of affected employees to provide certain information to those employees' representatives. And then a separate duty to consult arises when the employer envisages that it will be taking measures in respect of its own employees in connection with the transfer. Who the affected employees are should be straightforward to identify in terms of pension changes. It will be any employee affected by a pensions change which comes about as a result of the TUPE transfer. And this is the case whether the changes are relatively minor or are substantial. It is possible that either the transferor or the transferee have information and consultation obligations, because the obligation arises when employees are affected by the TUPE transfer or may be affected by measures taken in connection with it. This might include either the transferor's employees, as is commonly the case, or the transferee's employees, for example, if restructurings are envisaged following the transfer as a result of the influx of new employees. Or indeed, both sets of employees might be affected by the transfer, which would necessitate both the transferor and the transferee to engage in this information and consultation process. But when we're talking about pensions changes which are envisaged immediately following the TUPE transfer, in most cases it's reasonable to assume in practice that this is a transferor obligation to inform and consult, but with necessary inputs needed from the transferee on the measures it envisages taking in relation to the transferring staff. So the first thing to note is that there are two distinct duties under TUPE, the duty to provide information and then the duty to consult. So firstly, what information must be provided? Well, certain information to affected employees' representatives must always be provided in a TUPE transfer situation. Alongside the basic information which TUPE requires the employer to provide to the appropriate representatives about the proposed transfer, so for example, the date when the transfer is expected to take place, the reason for it, the legal, economic and social reasons for the transfer. There is also an obligation to provide information on any measures which the employer envisages it will take in connection with the transfer in relation to any transferring employees. And the transferor employer has an obligation to inform the representatives of any affected employees of any measures which the transferee envisages it will take in connection with the transfer in relation to any transferring employees. So in order that the transferor can provide that information to the representatives, this necessitates some engagement from the transferee. So essentially it's a two-way process where both the transferor and the transferee have obligations to engage to ensure sufficient information is provided to the affected employees' representatives. So what are measures? Well, measures is a bit of an elusive term. It's not defined in the TUPE regulations. But case law has told us that measures is very wide in its meaning. It could embody something as discrete as a change in payroll dates, or much bigger, more significant changes, so for example, restructuring or redundancies envisaged as a result of the transfer. The measures referred to must be definite plans or proposals, so not mere hopes or possibilities of things that might happen after the transfer. And in terms of today's talk, you should always assume it includes any kind of change of pensions provision. So measures would include ceasing accrual in the transferor's pension scheme, even if that's automatically going to happen, because the employees automatically become deferred members of that pension scheme as a result of the TUPE transfer. It would include a change in the type of pension scheme, so for example a change from defined benefit to defined contribution pensions. And it would also include a very simple change, say the provider of the pension. And a common example is where a transferring employee is offered membership of a group personal pension scheme before the transfer, and the employer after the transfer also offers a GPP to its employees, but it's not provided by the same insurer. So even a change in provider, so for example Standard Life, to another insurer following the transfer, so for example Scottish Widows, that would be a measure. And even if the changes are seemingly small, the transferor should look to include as much information as possible about seemingly smaller changes to the pension scheme. So for example, changes to the scheme's investment rate, any charges, differential charges between the two pension schemes, that would need to be included. And measures will also include advantageous as well as disadvantageous changes. So even if the pension scheme on offer following the transfer is actually an improvement for affected employees, and this does sometimes happen, this should be included as a measure. Now, I mentioned there were two aspects to the TUPE information and consultation duty. I've just talked about the information requirements, and so turning to the consultation duty. Now, if there are any measures envisaged in relation to an affected employee in connection with the transfer, the employer of affected employees must enter into consultation with the appropriate representatives with a view to seeking agreement to the intended measures to be taken. And practically, we often see this as a tripartite consultation process taking place between the transferor, the transferee, and appropriate representatives, so them all working together to ensure that the information and consultation obligations are properly satisfied. In terms of the timing of the consultation, TUPE doesn't prescribe minimum timescales, and it will very much depend on the nature of the measures being proposed by the transferee and the significance of those proposed changes. What we do know is that the employer must give the information to the representatives, including details of any pensions changes envisaged, long enough before the relevant transfer to enable the employer to consult the appropriate representatives of any affected employees. So essentially, to be meaningful, this must allow those being consulted to have time to consider, digest, and then raise any queries with the consulting employer. So if the only change that was being proposed was a small administrative change to the pension scheme on offer for the transferring employees, with everything else remaining the same and no other wider changes for TUPE purposes, it would be reasonable to assume a relatively short consultation period, so for example a week or two would suffice. If by contrast some substantial and perhaps controversial changes were being proposed to the employee's pension arrangements to the extent allowed by TUPE, I could envisage a longer period of pre-transfer consultation being appropriate in order to satisfy the requirement that it is meaningful. So what about allegations that there's been a failure to comply with these obligations? Claims can be brought to an employment tribunal by either a trade union or the employee's representatives or any affected employees, and the claim should be brought within 3 months of the transfer, although the tribunal does have discretion to consider a longer period where it accepts that it wasn't reasonably practicable to bring the claim within the 3-month period. And if the tribunal agrees that there's been a failure to inform and consult as required by TUPE, the transferee and the transferor can be found jointly and severally liable in respect of any compensation payable. So collectively and individually they have a responsibility. And a successful complaint of failure to inform and consult under TUPE will result in a declaration by the Employment Tribunal and award of compensation of up to 13 weeks gross pay for each affected employee on an uncapped basis. So it's something to be taken seriously. And the award isn't to compensate the employee for any loss they've suffered as a result of the breach. Instead, it's intended to take into account the seriousness of the employer to comply with its duty. So it's essentially a sanction. And the tribunal has a wide discretion here. Where there's been no consultation at all, the tribunal will start with the maximum award and then we'll look to see if there are any mitigating circumstances to take into account. So moving on to pensions consultation. Separate consultation obligations can arise under the catchily named occupational pension schemes, consultation by employers and miscellaneous amendments regulations 2006. Which I'll refer to for simplicity as the Pensions Consultation Regulations. And these regulations impose an obligation to consult with affected members of the pension scheme. This means consultation with either active members of the scheme or prospective members, being those who are eligible to join, and their appropriate representatives. The obligation to consult here arises when certain listed changes are being proposed, and these listed changes can include changes to both the personal pension scheme, which is always defined contribution in nature, or a change to an occupational pension scheme, which might provide either defined benefit or defined contribution benefits. And the reason why I mention these regulations in the context of a TUPE transfer is that, of course, pension changes are often proposed as a result of a TUPE transfer, if only because it's the case that a transferee employer may simply be unable or unwilling to offer ongoing membership of the same occupational pension scheme which was on offer before the transfer. So So this might mean that you have both affected employees, as we've seen, for the purposes of the TUPE information and consultation obligations, but also affected members in respect of the pensions consultation regulations. Where the requirement exists, the pensions consultation period must run for a minimum 60-day period, which can seem relatively onerous by comparison with the less prescriptive requirements of TUPE, at least in terms of timescales. And the pensions regulator has the power to issue a penalty of up to £50,000 where the pensions consultation requirements have not been complied with. And this would be in response to any complaint to the regulator by any representative of an affected member or by the affected member themselves. So in the TUPE transfer context, is there a requirement to do pensions consultation? And if so, who should be undertaking that consultation? Well, there's always been ambiguity about whether pensions consultation obligations do bite in the context of a TUPE transfer, because, as we've seen, there is already a separate freestanding duty on the employer of affected employees to inform and consult about changes anticipated by the TUPE transfer, including measures. And we've seen that a broad interpretation should be taken and should certainly be taken to include pensions. But there is no clear exclusion in the pensions consultation regulations from the duty to engage in consultation, even where TUPE consultation is already taking place. So the transferor and transferee should at least be considering whether pensions consultation is needed in the circumstances. Now, the key point in relation to the pensions consultation regulations is that the duty to consult is placed on the person proposing to make the listed change. Now, that's pretty easy normally to establish where there's an ongoing employer in relation to a pension scheme. If it wants to make changes to the scheme or the benefits being provided to the employees, the duty to undertake pensions consultation clearly arises. This is more problematic where a TUPE transfer is expected to take place. First, there's an argument that pensions changes are taking place as a result of the TUPE transfer and the automatic transfer principle. So there's no decision maker as such who's actually deciding to stop providing pension benefits into the pre-transfer pension scheme. Second, the transferee is proposing to make pension changes as a result of the TUPE transfer, but that transferee is not the employer in relation to the pre-transfer pension scheme. So it's not the employer for the purposes of the pensions consultation regulations. Now, it's possible that the transferor should be undertaking the pensions consultation. It's the employer in relation to the pre-transfer pension scheme. But equally, it might reasonably say, well, these changes are only being made as a result of the operation of TUPE. And so even though I, as the transferor, am the employer of the scheme in question, I'm not actually proposing the listed change. And to the extent that the transferee is proposing pension changes, again, I, as transferor, don't have an obligation to consult on the transferee's behalf, unlike in relation to the TUPE regulations. So what's the best course of action in the face of this uncertainty? Well, part of the answer to this question will depend on the timing of the proposed changes. Where there's some delay in any plans by the transferee to make pension changes, so for example, the pension changes aren't going to take effect until several months after the transfer date, it's quite clear that to the extent that the change is a listed change, the transferee will need to undertake pensions consultation with affected members and their representatives for a minimum 60-day period. By contrast, where pensions changes are being proposed at the point of the TUPE transfer, so the transferee is proposing to put in place new pensions provisions immediately following the transfer date, it's very unclear under the pensions consultation regulations whether the duty to inform and consult does arise. Taking a cautious approach, the transferor and transferee should at least consider whether or not it should be consulting in the context of what the pension changes are and when they are proposed to take effect, and take legal advice if necessary. If it becomes apparent that for whatever reason no pensions consultation is intended prior to the transfer, either because the transferee doesn't have access to the transferor's affected members or their representatives to enable that pensions consultation, or simply because the transferor doesn't consider it has the obligation under the pensions consultation regulations, there could be a risk of claims for failure to consult for pensions consultation purposes. There are just a few points to note on this point, however. Firstly, because it's not clear whether the pensions consultation duty would arise where pensions changes are proposed at the point of the transfer, a failure to undertake pensions consultation could be relatively low risk. And it may be helpful to know that, firstly, we're not aware of the pensions regulator having issued any fines to to date for failure to comply with the pensions consultation regulations, whether in a TUPE context or not. And even if the regulator were to do so, whilst employers won't want to be hit with a £50,000 fine, it wouldn't mean that any pension changes that are going to take place as part of the TUPE transfer would be rendered void or ineffective. And that may be some reassurance to transferee employers. And practically, it seems to us that the main way of minimising any risk of failure to comply with the pensions consultation regulations is to ensure as a bare minimum that the transferor and transferee fully comply with their obligations to inform and consult under the TUPE regulations. This is where the clear legal duty to inform and consult arises, and where both the transferor and transferee have respective legal duties to provide a forum in which those pension scheme changes can be consulted on. So as such, whilst not a risk-free approach, I would expect that a meaningful TUPE information and consultation exercise, which lasts several weeks and covers pension changes anticipated by the transfer, would go some way to deal with allegations of non-compliance with the pensions consultation requirements.
Great, thank you, Liz. Just a reminder, there's still time to send your questions in. We've had quite a few come in already, but there's still an opportunity for you, whether it's something that has occurred to you during the speaker's presentation so far, or if it's that question that's sitting on your desk and you're desperate to know the answer to, please do send it in. Now, the next question we're going to be dealing with is Beckmann liabilities, and Hannah will be looking at that in terms of what are the issues in how you can go about buying out or settling Beckmann rights or other tricky pensions issues.
Thanks, Siobhan. Before I start to answer this question, it's probably worth taking a step back to think about why you might want to enter into a settlement of pension rights in the first place. I've suggested some reasons on the slide here. Firstly, and this is a point that's not limited to pensions, the transferee might want to harmonise benefits across its workforce insofar as you can do that following a TUPE transfer, and I'll come back to the restrictions on this in a minute. But essentially, having different pension benefits for different groups of staff can create extra administration and complexity, as well as fairness issues, and so that's one reason an employer might want to try and change the pension rights through a settlement. Secondly, there may well be practical issues with providing the pension rights that an employee is legally entitled to after a transfer. A classic example here is Beckmann rights. For example, the right to a defined benefit early retirement pension, where the transferee doesn't actually have a defined benefit pension scheme that could provide the benefits. The third reason you might want to change pension benefits is related to this. It's cost and uncertainty. Although we do now have a bit more case law than we used to about the scope of Beckmann liabilities, I'm talking here about the Procter & Gamble case some of you will have heard about, it can still be very difficult and expensive to quantify some kinds of pension liabilities and benefits. And finally, an employer might be thinking about making staff redundant or otherwise dismissing them, and that might be the reason for needing to reach a settlement in relation to pensions. So, there are a lot of reasons why an employer might want to settle pension benefits, but unfortunately it's not always a straightforward thing to do. This is because there are several provisions in both employment and pensions law which would need to be considered and complied with. On the pensions side, the main issue is a section of the Pensions Act 1995 which prevents the surrender of an entitlement to a pension except in very limited circumstances. On the face of it, this would be a major problem in reaching any kind of compromise where the employee accepts anything less than his full pensions entitlement. However, there are a couple of points which might help you depending on the circumstances. Firstly, there is some pensions case law, specifically the cases of IMG and Gleeds referred to on the slide, which make clear that Section 91 does not prevent you compromising or settling a genuine dispute about a pension scheme member's rights. To put this in simple terms, if a member is entitled to a pension of £100, he can't accept a pension of £90 instead. But if there is some dispute about the amount he's actually entitled to, so it could be £100 or it might be £50, you can settle that dispute. And this is often helpful where an employer is trying to compromise something like a Beckmann right, because there may well be a dispute about the value of the benefit. The other point to consider is whether Section 91 is relevant in all cases. This is coming back to the scenario I mentioned earlier, where the transferee has an obligation under TUPE to provide some kind of defined benefit pension, but it doesn't actually have the pension scheme that the right derived from originally. In this kind of case, it will be worth exploring further with your legal advisors whether Section 91 is relevant for the transferee at all. Moving on to employment considerations, this will probably be more familiar territory to those of you who deal with TUPE quite regularly. We could dedicate a whole webinar to this issue, so I'm going to keep it fairly high level for today. In order to protect transferring employees, TUPE prohibits post-transfer changes where the sole or principal reason is the transfer. But there are some circumstances where contractual variation is permitted. It follows on from the previous slide that contractual variation is allowed where the sole or main reason is not the transfer. There are also some other limited circumstances where variation is permitted by TUPE. All of this has been covered comprehensively in other webinars and insights on our website, so I'm not going to go through the detail today, but all I'd say from a TUPE and pensions perspective is that you need to work quite carefully through these limitations and restrictions in order to make sure that any compromise or settlement agreement you reach would be valid. So coming back to the question, can you settle or compromise pension rights after a TUPE transfer? The short answer is potentially yes, but it may be complicated and each case will have to turn on its facts. A settlement agreement of some kind may well be possible, but even so, it would need to be very carefully drafted to ensure that you mitigate the risk of the settlement being challenged at a later date.
Thank you very much, Hannah. So we're now on to the fifth and final question that we're covering before we go to your questions, and Liz will be dealing with that, and that is, what is a protected person status and when do you need to worry about it?
Okay, then we've never looked at protected persons in any of our previous webinars on TUPE and pensions, but it keeps coming up in terms of the actual work that we're doing for clients, so we thought that it was worth mentioning it in case you've not seen it before. Now, when some nationalised industries were privatised in the 1980s and 1990s, arrangements were put in place requiring a new private sector employer to continue to provide pension benefits for employees who were employed at the time of privatisation, which were at least as good as those that they were receiving in the public sector. And these obligations prevented the employer or the scheme from making changes which reduced future pensions accrual, and the legislation here is very specific to a number of industries, so electricity, rail, including London Transport, and coal. And whilst protected persons' rights and an associated right called the indefeasible right may seem relatively obscure if you've never come across them, where you are faced with an imminent TUPE transfer involving employees with these rights, it may be helpful to know firstly what the rights are, secondly how long they continue to apply for, and the ways in which the rights can be given up, modified or lost. Now, most protected persons are in the rail industry, but they are also present in a number of the privatised power companies. But I'm going to use today the rail industry as an example of the protections. So, for example, employees and members of the British Rail Pension Scheme at midnight on the 4th of November 1993 were protected persons, and this means that they had a legal right to pension provision for their future employment, which would be no less favourable than the relevant pension rights that she or he had under the former British Rail scheme. So the relevant legislation for rail workers who are protected persons is the Railways Act 1993 and the Railway Pensions Protection and Designation of Schemes Order 1994. Now, the members' pension rights must be at least as favourable as the rights which the British Rail scheme provided on the 31st of May 1994. This means the protected person's employer is legally obliged to provide an occupational pension scheme which meets these requirements. This is not straightforward, as actuarial and legal input will be necessary to ensure that any scheme the employer uses meets this requirement. Now, in reality, most employers we see with protected persons will choose to discharge this obligation by becoming a participating employer in the Railways Pension Scheme, which is the industry multi-employer, non-associated scheme for employees in the railways industry. And the protections mean that an employer of protected persons could immediately assume responsibility for some very large liabilities depending on, firstly, the number of incoming employees with the protected person status and their length of service with benefits accruing in the pre-transfer pension scheme. So, for example, if you identify just 10 protected persons on a TUPE transfer, there could be some quite hefty costs associated with providing ongoing benefits in line with their protected person status. but also liabilities in relation to their rights to transfer in the rights that they had in relation to their pre-transfer employer's pension scheme, particularly likely to be an issue where they've been in pensionable service with their former employer for a number of years. So how long does the protected person right continue? Well, it continues even if the ownership of the employee's employer changes, so for example on the sale of its shares, or, importantly for today's discussion, the employee's contract of employment is transferred. So for example on the sale of all or part of a business or change of service provider, so any of the scenarios which could give rise to a TUPE transfer. So it could mean that you inherit protected persons on a TUPE transfer, and they will have these significant protections which you, as the new employer, will be legally bound to honour, both ensuring ongoing defined benefit membership on a basis which is at least as stable as the rights they benefited from under their former pension scheme, but also taking into account of these generous transfer terms on which protected persons can transfer their accrued benefits to your pension scheme. So when is the right lost? Well, this protected person's protection is retained unless and until the protected person voluntarily leaves their employer, withdraws from the railway pension scheme, or agrees to modify or waive their protected status. And unlike many TUPE protected terms and conditions, which makes it challenging to vary employees' contracts following a transfer without falling foul of the TUPE protections, the statutory framework governing the protected person does helpfully allow members to voluntarily agree to modify or waive their protections. This can be helpful for employers because providing defined benefits on a basis equivalent to what was on offer to the protected persons before the transfer can be particularly problematic, especially when it involves small groups of employees. But this then leads on to an exercise in terms of how you get the employees to agree to this. A careful process would need to be followed. It's an employee election that's required, and it's an election to the trustees of their pension scheme. And I would expect a thorough, transparent and fair consultation process to have been followed before any decisions are asked of employees to consider modifying or waiving part of their protected person status. And it's also extremely likely that you'll need to get both legal and actuarial input on any proposal put to the protected persons to seek their agreement to give up, either in part or entirely, these protections. There's also a separate right under the legislation called the indefeasible right. And this slide may look familiar. You've seen this previously in relation to protected persons. So not only by virtue of employment status as of the 4th of November 1993 did they gain the protected person right, they also gained something called the indefeasible right. And this protection is a statutory right to continue to be a member of the industry scheme until the indefeasible right ends. The protection remains in place as long as the employee remains in employment. However, the employee here will also retain the right even if they leave employment, as long as they are re-employed with a railway industry employer within 6 months of leaving. And there's a very wide definition in the legislation of what a railway industry employer is. If they apply to rejoin the scheme within 6 months of leaving employment, and then rejoining the scheme takes effect from the start of that new employment, and they haven't been employed outside the railway industry between leaving and rejoining, that right continues. And unlike the protected person right, which is to membership of a pension scheme which provides benefits no less favourable, the indefeasible right is to membership of the industry pension scheme. So here that would be the railway's pension scheme. So how does the employee retain the right? Well, similarly to the protected persons, continuity of employment means they keep the right, and the right is also maintained on the transfer of employment to another railway employer. How does the employee lose the right? Well, on leaving railway employment, but also on the employee choosing to give up the right. So again, the legislation helpfully provides for an election process to give up the indefeasible right. So in terms of the main points to take away on protected persons and indefeasible rights transfer with the employee's employment, so they may come across to you on a transfer of employment. Transferee employers must abide by the statutory framework to protect the value of these employees' pensions through the provision of ongoing pension benefits. If the employer wants to look to the employees to modify or change these rights, a consultation with employees would be appropriate to ensure that employees can be said to properly give up the rights. And legal and actuarial input is likely to be needed to ensure that the employer has complied with the provisions contained in the statutory order, either in relation to providing those benefits on an ongoing basis or in relation to any discussions with the employees to give up or modify those rights. And practically, in our experience, it's likely that the trustees of the Railway Pension Scheme will want to be satisfied with the process taken to seek the employee's election to give up or modify these rights. And so any employer would want to involve the trustee at an early stage to ensure that it is in agreement to the proposed approach.
Thank you very much indeed, Liz. And that wraps up our questions that we've set out to answer today, and it's over to you who have been submitting questions. So Hannah is going to pick up one of those questions.
Thanks, Siobhan. Okay, so the first question I'm going to pick up says, are there certain kinds of schemes or situations where Beckmann liabilities are more likely to be a problem? I think the answer to that is yes, definitely. So Beckmann liabilities arise where transferring staff have been members of a defined benefit pension scheme in the past. And this means there are some sectors where defined benefit pensions are more common. So, for example, the public sector, manufacturing or financial services are much more likely to have a history of defined benefit pensions than, say, a new tech startup company, where all the staff are relatively new hires. On that point, though, it's also worth remembering, I think, that Beckmann liabilities might come from an historic transfer. So in an outsourcing scenario, even if the current provider doesn't have a defined benefit pension scheme, it's possible that a provider in the past did, and so there may be Beckmann issues that flow through to the next contractor, so that's a point just to be aware of.
We've had a number of Beckmann questions actually, so I'm going to pick another one of those up. So one question is, how frequently and with what level of success do Beckmann claims end up in explicit claims against companies? So, for example, where the claims aren't washed away in settlement agreements at the end of employment. And that's a really interesting question, and we as lawyers spend a lot of time trying to identify if a Beckmann or Martin right exists in a pension scheme rules. But actually, in terms of claims, I think both Hannah and my experience is actually they're pretty rare. I think there are a number of reasons for that. I think, firstly, even as pensions lawyers, Beckmann clauses in pension schemes are not always very, very clear to identify. They can often depend on very old pension scheme